I'm Chris Carl, and these are some of the stories reported in recent issues of LexisNexis Mealy publications. A federal judge in Arizona has stopped 4 provisions of Arizona's new controversial immigration law from going into effect. They are the provisions that require an officer to check the immigration status of anyone stopped, detained, or arrested, that make it a crime not to apply for or carry alien registration papers, to make it illegal for an unauthorized alien to seek or perform work, and that allow an arrest with no warrant if there is probable cause to believe that the person has committed a public offense that makes him or her removable from the country. The California Supreme Court on July 26th found that contingency fee agreements between numerous California municipalities and their council as part of a decade-old public nuisance suit against the lead paint industry are deficient under California law. Trial courts have based its holding that public entities were barred from compensating private counsel via contingency fee agreements on a 1985 ruling. But the California High Court said that opinion should be narrowed to recognize the variety of public nuisance actions and the different means by which duties may be delegated to private attorneys without compromising the integrity of the prosecution. The court said retention of private counsel on a contingency fee basis is permissible in the prosecution of public nuisance abatement actions, provided that neutral, conflict-free government attorneys retain the power to control and supervise the litigation. Citing a series of errors by a federal judge in California, the Ninth Circuit U.S. Court of Appeals in July vacated an order that awarded toymaker Mattel near total control over a competitor. LexisNexis legal editor Steve Bursler explains.
Well, Mattel's 2004 lawsuit alleged MGA Entertainment, among other things, misappropriated trade secrets from Mattel employees and committed copyright infringement related to MGA's Bratz line of dolls. After a jury awarded Mattel millions of dollars in damages for copyright infringement, the district court ordered the entire Bratz worldwide trademark transferred from MGA to Mattel for all dolls bearing the Bratz trademark. The lower court also cited direct competition between the doll designs as grounds for ordering the impoundment of all Bratz dolls and the destruction of their plates, molds, and matrices. Vacating that ruling, the Ninth Circuit said, quote, "It is not equitable to transfer this billion-dollar brand, the value of which is overwhelmingly the result of MGA's legitimate efforts, because it may have started with 2 misappropriated names." The Ninth Circuit concluded, quote, "America thrives on competition. Barbie, the all-American girl, will too." Chris?
Thanks, Steve. A federal judge in New York has ruled that a class action alleging that a popular line of soft drinks are falsely marketed as providing health benefits to consumers can proceed. The Eastern District of New York lawsuit alleges the Coca-Cola Company and Energy Brands Incorporated engaged in deceptive marketing practices involving the vitamin water line of drinks. The plaintiffs maintain the companies market vitamin water as being able to reduce the risk of chronic disease, promote healthy joints, and support optimal immune function. A Los Angeles judge has held that the Constitution does not support a jury's $200 million punitive damages award in an asbestos case. Granting Certainteed Corporation a new trial, an L.A. County Superior Court judge also found a jury's failure to find liability on the part of third parties goes against the weight of the evidence and compromises the entire verdict. The judge explained that the jury was instructed to decide how much at fault a third parties contributed to a women's mesothelioma. The verdict sheet provided 3 parties in addition to Certainteed, but the jury did not allocate any fault to the third-party entities, the judge noted, despite sufficient evidence upon which it could have done so. The Judicial Panel on Multi-District Litigation has been asked to centralize 7 federal lawsuits against McNeil Consumer Healthcare and parent company Johnson & Johnson for consumer law violations stemming from recalled over-the-counter drugs made at the company's Fort Washington, Pennsylvania plant. LexisNexis Mealy's Drugs and Devices editor Tom Moylan is following the litigation. Tom, what's at issue in these consumer actions?
Chris, the plaintiffs are seeking under state consumer laws to recover money paid or overpaid for non-prescription children products under the names of Tylenol, Motrin, Zyrtec, and Motrin. These were products that were made as cold remedies, allergy remedies, or pain relief remedies. Plaintiffs are saying that the defendants knew that the products were contaminated and that there was a lack of quality control at the plant where they were made.
Where do the plaintiffs want the cases centered and why?
Chris, they are asking that the cases be sent to the U.S. District Court for the Northern District of Illinois before Judge John Nordberg. That's because 6 of the 7 cases that have been filed already are pending there. They say that the court is centrally located and that its docket can accommodate a new MDL.
And Tom, have the companies responded, and when might the panel decide if these cases are worth consolidating?
About 3 days after the plaintiffs filed their motion, Johnson & Johnson and McNeil filed what they called an opposition. In actuality, the defendants say they support centralization of the cases. They just don't want it sent to the Northern District of Illinois. Instead, they're proposing that it be sent either to the District of New Jersey or the Eastern District of Pennsylvania, saying that witnesses and documents would be more available. Of course, McNeil and Johnson are located in the District of New Jersey and the Eastern District of Pennsylvania. Now, the earliest that the JPMDL is going to hear this motion is at its September 30th meeting, which would make a decision come down about mid-October.
Thanks, Tom. GlaxoSmithKline disclosed during a quarterly financial report that it's reached an agreement in principle to settle the vast majority of cases involving its Polygrip denture adhesive. Plaintiffs allege they were exposed to excessive amounts of zinc used in Polygrip. The company is one of two primary defendants in denture adhesive litigation in the country. The other is Procter & Gamble, which makes Fixodent. In making the announcement, GSK did not say how many cases are being settled or the settlement amounts. The Securities and Exchange Commission announced July 22nd that computer manufacturer Dell Incorporated has agreed to pay a $100 million fine to settle charges that the company made misleading statements to investors. The SEC's complaint alleged Dell committed various disclosure and accounting violations between 2001 and 2006 by failing to disclose significant benefits it received from large payments from Intel Corporation in order for Dell not to use central processing units manufactured by Intel's main rival, Advanced Micro Devices. The California Attorney General in July officially announced that the state had reached agreements with two makers of synthetic turf in which each would pay fines and costs of litigation for a combined total of $481,000. In addition to fines, the companies will cease installation of synthetic turf athletic fields in the state. In 2008, Attorney General Edmund G. Brown Jr. alleged the turf contained excessive levels of lead. Both manufacturers are required to mail a warning to all customers who purchased its products in California in the past 5 years, informing them the turf products they purchased contain lead, outline maintenance practices, and advise them of the availability of the program to test and replace old turf products. You can get more details on these and many other stories at LexisNexis.com/Mealies. For LexisNexis Legal News, I'm Chris Carl. Thanks for watching.